The draft agenda review, amendments, and approval. We have amendments to the draft agenda. Nothing to be added. Entertain a motion that we approve the agenda as set forth in the draft. All those in favor? Aye. The next is mayor and council comments and discussion.
I've got one item. CAMA land use plan draft. I've been through this twice. First time I marked it up. Second time we got another version and those changes hadn't been made. I marked up that version. It was missing half of the pages. I gave you a package with that version marked up, and we had a long meeting on CAMA. We went through all those problems and issues and potential changes. Apparently, somehow that's gotten lost in town hall. I am not going and reading through these things again. This thing, I've done it twice. I've marked it up. It is not fair. Somebody can go through and listen to the tape of the meeting. If you can't find what I handed you and mark this thing up, not one change has been made in this. How are we supposed to have a final meeting with not one change from all the discussions and 2 meetings that we had were incorporated into this latest document? So I am not doing it again. Just telling you, I'm not doing it again. Somebody needs to go through and fix that.
Carol, for clarity, when we had the meeting here in Town Hall, I talked about probably 10 or 12 changes, and each one of them was reflected in the latest version. Are you saying that your marked up margin notes got lost?
Yeah, and I looked through, I had to go back to my first version, which only has half the pages, because half of the pages I pulled out to make the second version complete with those things, and most of those changes were not incorporated. And a lot of them are word changes. We may rather than we will. One of them had to do with, I remember saying it at the time, a discussion,
Do you have another
there
copy?
was something in there on CR1, and all of a sudden, they were changing it to 5-acre zoning instead of 1-acre zoning. I don't think we can use a CAMA land use plan to make a change like that with council having never even discussed changing zoning. I don't think it's legal. I don't think we should be doing that. And since I don't have all the other pages, it's very hard for me to tell you that this change was made or not made. What I'd like somebody to do is go watch the tape. All of those changes were discussed, mark up a version, and give me a version that has my changes in it, or find what I gave you. It's just not fair.
Now, you want this in advance of the meeting that we have
Yes.
scheduled? For, when's our meeting, 2 weeks?
October 12th.
Less than 2 weeks. I'm puzzled, Carol, because every one of my changes was reflected by
I can
Hiram.
go through and, as I said, I can just show you from my first version, and since I don't have the second version, I can't tell you if I said, oh no, that's okay, or that's not okay, because I don't have it.
I hear you.
Carol, who had your notes?
I gave them to Lisa. Last time I saw them, Lisa had the
Do you know where they are? Oh.
This thing is like 300 pages long. I'm not doing it again. I've done it religiously, more so than most people on this council. Not everybody, but most people. And it's not fair. So somebody else can go through and listen to the tape and mark up a version and give it to me. Okay?
Lisa, you lost it.
All the changes were made.
Even Carol's changes
I know
were
they
made?
weren't, because I can come up with words in this thing that I know I wanted changed, and they were not changed.
I'll double check with Wes to see what he's got as far as his notes from that meeting. He's the one who made the changes. But he's on vacation this week, so I'll do my best to get hold of someone in the cog who may have access to this stuff.
Is that fair, Carol?
Sure.
Okay, I have a few comments. One is, occasionally I receive written complaints. I'm not complaining that I receive written complaints, but they're unsigned, and there's no way I can contact or respond to the author. So and I really do try and respond to people when they do make comments and whatnot. So I just caution anybody that when you make comments, I'm not trying to cast aspersions on people or pick on people or whatever, but I can't respond if I don't know who to respond to or how to respond to them. The second thing is that we had a Brunswick County Mayor's meeting last week with the Commissioner of Insurance, the North Carolina Commissioner of Insurance. It was an interesting meeting in that I learned, for instance, the Commissioner of Insurance is also the State Fire Marshal and also responsible for all of the building inspection offices. The primary focus of the conversation was on wind and hail, and the head of the North Carolina Wind and Hail was there as well. They were talking about insurance costs and the problems with roof damage on barrier islands. They're looking to enhance roof construction requirements, particularly on rebuilding after weather events. And they're also trying to bring in considerably more private companies to write the insurance, and they've received some favorable response. There seems to be more companies interested in writing it, so there'll be more choices, which obviously would have an impact upon rates. They presently have in their beach plan $1.5 billion in reserve. This is the state does. And during for Matthew claims, they paid over 23,000 claims. This is the wind and hail of the state, paid over 23,000, and they were all paid within 60 days of submission, and not one resulted in litigation. We also had conversation with the representative of Congressman Rausser's office, and concern was when is the suspension on the FEMA Matthew money going to be lifted? And this, of course, was before Maria and its impact on Puerto Rico. But they didn't have any date, but they're looking at possibly the earliest possible is in May of 2018. This is FEMA reimbursement for municipal costs that were spent for cleaning up Matthew. Another thing, I've been had conversation with some individuals on council that we would like to see a report by council liaisons to various committees so the rest of the council knows what's going on with regard to those committees, and that it be a regular part of our agenda. The last thing that I have is for council information is I've taken steps to contact or I'm taking steps to contact the Sunset Beach Business and Merchants Association with regard to the $105,000 that the town provided. There were 9 conditions of that grant. It was a grant, and there were 9 conditions imposed in that grant that they acknowledged in writing that they had to comply with, which we found no evidence of compliance. Without reading exactly what they are, my contact with them is going to be the demand for the detailed records in accordance with those requirements, and asking that information be provided within 30 days because we've never received them. One of the requirements is that monthly reports be filed, and there was some information filed up until June of 2016, but it's not in compliance with those 9 requirements. I just want to make you aware that on behalf of the town, I will be contacting the Businessmen's Association. I also want to request everybody keep in their thoughts and prayers the people in Puerto Rico, the people in Florida, the results of the hurricanes, and the people in Las Vegas that were impacted by the recent event that happened last night, the shooting that happened in Las Vegas. Okay, now we can go into the 7 o'clock meeting. I request everyone join me in pledging allegiance to the flag. The next item on the agenda are the minutes for August 31st, September 5, and September 19. We can adopt them as one unless anybody has any corrections to those minutes. Everybody's received them ahead of time and had opportunity to communicate with Lisa. None appearing, I'll have a motion to adopt the minutes for those three
Mr. Mayor, I'd
meetings.
like to file a motion for the minutes approval for August 31st, September 5th, and September 19th, 2017.
Discussion, all those in favor?
Aye.
Opposed? Next item is public comments on agenda items. When you step forward, if you have a comment you want to make on an agenda item, please step forward, state your name and address, and limit your comments to 3 minutes. Yeah. Before we get into that, though, for purposes of brevity, if you intended to comment about this, there are several items listed on the agenda where there are some modifications. The proposed access to the 12-foot access to the Twin Lakes Restaurant is in the process of being developed. It's not, no action's going to be taken or further discussion would be taken in the regular portion of this meeting with regard to that. The same with regard to the East End Emergency Access Agreement, easement, excuse me. That also, additional work has to be done on that. There's going to be no action taken or discussion of it at the meeting. The appeal hearings would go forward. There's been a request, according to council, with regard to an adjournment, but we'll deal with that. The Metcalf roadway will deal with that. The ordinance amendment for the BB1 district. What do we do with that? That's going forward, isn't it?
Yeah,
That's going to go, that's going forward.
yes.
The park rules. It's obvious there's a substantial interest in the park rules and the documents. There have been various submissions made by council members, by the administrator, and by the attorney, some of which were not received or haven't been received until fairly recently. And although we're going to discuss and try and reach an understanding on a lot of the issues tonight, there's going to be no formal action taken on it tonight because we have to get a finalized version that we can vote on. And so the vote won't be taken tonight, but there will be discussion. With regard to the conflict of interest policy,
That is presently under review by Mr. Richardson and Ms. Parker. Ms. Parker made some suggestions, and Grady hasn't had a chance to get everything together for us, so maybe you have.
well, it's,
Hold it. Susan?
I was going to say, Grady did have an opportunity because it was part of the packet, and he has made one single recommendation, and when we'll go ahead and he can read that to you, and then you can actually probably take action tonight, but he also has some comments regarding it
All right,
itself.
so that'll be carried to the next meeting?
I think you can do it tonight.
Okay.
all right. Those are the
Take
other,
action.
those are the only comments on the things that are on the agenda. All right, now it's opportunity for anybody who wishes to make a comment with items on the agenda. Sir, come forward, please. State your name and address.
Sure. My name is Tim Jackson. The address is 1510 North Shore Drive East. And I'm not really sure I understood what you said about the appeal hearings for Palm Cove lots 8 and 9 we'd requested a continuance on that because we submitted some things that have not had a chance to be reviewed by local
Yeah, we're going to
officials.
discuss that. We were aware that there was a request for a continuance. We're going to
So
discuss it when it
are,
comes up.
is there some issue with granting the continuance?
Well, I don't know. what
I didn't
the-
understand what you
I have
said.
issues, yes. You're a builder in this town, you should know the rules.
Well, Susan?
That's not
Susan?
necessarily, we haven't voted on it.
Wait, Susan?
Tim, that's a matter of discussion when we discuss it on the item. We'll do it at that time.
It's still on for discussion. It hasn't been taken off. Your request for adjournment has been,
It doesn't
is
mean
on.
that we won't grant it. It's just that we will be discussing the issue, and I can't give you an answer on that because we haven't taken a vote.
Okay.
So I'm sorry. Is that fair?
Other members of the public?
Dave Eastburn, 424 32nd Street. Recently, council has asked the attorney for opinions whether actions by certain council members violate the North Carolina conflict of interest laws. Council has also asked staff to, and I quote, explore conflict of interest policies in other municipalities. This is all well and good, but it's the wrong questions. The North Carolina conflict of interest laws cover conflicts regarding granting and administering contracts. It doesn't cover other types of conflicts. It only covers actions by individual council members, not their extended family or business relations. And it only covers direct financial benefit, not other types of benefit. And there are exclusions for small municipalities, which means that none of this stuff applies to the town of Sunset Beach. So when we ask the questions, we ought to be asking the right questions. What we should be asking is, are these actions ethical? Do they meet the town's own code of ethics, which Susan discovered when she was doing her research and produced as part of tonight's packet, which includes not only the letter, but the intent of the law? We should also be asking, is this consistent with the North Carolina Ethics Act? There is an Ethics Act in addition to a Conflict of Interest Act within the state of North Carolina. And the spirit of the Conflict of Interest Act as well. What we should be doing is complying with not only the letter, but the intent of these acts. And we should be following the guidelines of recusal published by the North Carolina School of Government. The Ethics Act covers more than conflicts merely for contract administration. It covers more than direct financial benefit. It covers extended family members, business relationships, not just the council members themselves. And the Ethics Act restricts a public servant from taking official action if that action may result in a reasonably foreseeable financial benefit to the following individuals: the public servant or a member of the public servant's extended family, and a number of others. When a council member recuses themselves, the Ethics Act requires that they not participate in any written or verbal discussion of the matter. They should decline to participate in such discussions. They should not seek to accept information concerning the matter, and they should not vote in such matters.
Mr. Easterburn, we're over 3 minutes.
Excuse me?
We're over 3 minutes.
Okay, I'm finished too. Thank you.
The other public comment?
Good evening, Mr. Mayor, members of Town Council. My name is Matt Nichols. I was here for the Palm Cove appeal items, and I can address that at the appropriate time. I just wanted to make sure I had an opportunity to speak when.
Oh, yeah, certainly,
Yes, sir.
yes.
Thank
yeah,
you.
Certainly.
Ann Bockelman, 404 3rd Street. I'm happy to hear that you're only going to discuss the park rules tonight and not to vote on them, because they're quite lengthy, and since they were just made available to the public today, I know that many people have an interest in reviewing them carefully. I did want to just point out one thing, and you may have covered this, but in 99.07, I think it is, it talks about glass, and there shall be no glass permitted in the park. It doesn't say anything about having a permitting process if someone's having a special event. So if there's a wedding, don't you think those people might like to have a bottle of champagne? But that comes in glass. And when we have the Strawberry and Wine Fest in April, there is wine, and we do have wine that comes in glass. So I'm sure that's just an oversight, but I just wanted to point it out. Thank you.
Thank you. Other public comments? All right, none appearing. Move on to the next item. Before we get to the next item, though, in the comments, it was an error, and I didn't mention the fact that for anybody who's not aware, this Saturday is Sunset at Sunset, is our annual Sunset at Sunset. And I encourage everybody to attend, and want to make sure that everybody was aware of it. The members of the committee put in a lot of time and effort, and I encourage everybody to support it. That's this Saturday, the 7th of October. The next item on the agenda, no further public participation. The department reports. Police.
Good evening. I'd be happy to answer any questions you may have about the report. If there are none, I just want to remind everybody in a couple of weeks on the 30th, which is a Monday night, we're hosting our first annual trunk or treat event, which will be behind Ingram Planetarium from 5 to 6:30 p.m. I've sent an email to all of you. You're all cordially invited. Public is invited as well to come out and see that.
What was the ambulances out at the gazebo area Saturday around noon, 1 o'clock?
The ambulances at the gazebo area around noon. That may be, yeah. I'm sorry, I don't know. Thank you.
Any other questions? No. Thanks, Chief.
Chief, good job with liquor investigation.
Public Works.
Just like to add that with the pavement of North Shore and Cobia, the bid documents are being prepared.
Good. And good job fixing what your fellow friend over there did when they were testing all the fire hydrants and created terrible potholes all over everywhere. But that was good job fixing that.
You're welcome.
Any questions? Dustin? Thanks, Dustin. Planning, inspections?
Good evening. Again, y'all get a weekly from me, so I'll go over really quick. Over at Pelican Square, they're starting their redevelopment. They're going to be coming in conformity with our overlay, so they'll be doing the walkway. They're making sure everything matches up. They're painting the building for our colors. They're really trying to turn it around and bring in some more businesses to that shopping center.
For anybody who's not aware of Pelican.
Oh, it's the old food line, I guess. Behind Hardee's. Other than that, buildings going strong. While I was gone last week, I had 4 more structures come in, so.
I got a question for you. Is the church going to stay and Sarah's going to stay in that facility?
Sarah's is. I believe the church is vacating. They already have. Oh, yeah.
Are they relocating Sunset?
They're looking for another location. They've come in and talked to us about a few places. Without any formal application, I don't really know where they're actually looking at, but they've talked about a few buildings that I don't think would meet out for fire code reasons and whatnot. But I think for now, they found a temporary home at the community center out here behind us at the Sea Trail Community Building.
Okay.
For a few hours on Sundays, but they haven't found a permanent home yet. We're in the process of trying to help them find a few places when looking around.
Do they have any new businesses to come into that facility yet?
Yeah, this morning I permitted a Family Dollar.
No. You serious?
Yes, presently, that's the only new business, but, it's conforming with all the regulations. So that's about it right now.
How do all of these places stay in business?
I don't know the business
I don't
model.
understand it. There's one on every corner.
Carol, it could be a beach store.
It's Family Dollar Beachwear and Surf Shop. But,
I might like that better than a Family Dollar.
But they are looking at trying to get a few more restaurants and stuff in there as well. So I know their overall plan, but they haven't let us know who they're talking to.
All right, thank you, Hiram.
Yep.
Fire?
You have my report. Saturday's incident, there was a near drowning. Gentleman was pulled out of a rip current Saturday. Water's still rough. We've got a mean high tide coming this week along with a easterly flow, so we're going to have some really rough surf. Just be careful if you're out in the water the next couple of days. Any other questions?
How many, this is one of several that you've had, isn't it?
Oh, we've had quite a bit this year.
You know, have you got a number?
No, we're working on all that for our
Okay.
coming meeting.
Okay.
When we do the wrap up of the
Okay.
beach.
Any other questions? Thank you. Finance?
Hi, everyone. If you have any questions about the financial report, this is through the end of August. And also, there was more information provided about the FEMA moratorium. And so if anybody has any questions about that.
What is the impact on us of not getting those funds in a timely fashion?
It is,
I know what the dollar amount is, but the impact, I mean, does it affect operations? Does it?
no, not at all. We've already spent the money. And it, because it was spent in last fiscal year, when the money, if we were to have received the money prior to the moratorium, it would have been unbudgeted revenue. Because the FEMA money, because we never know when it's coming in, we can't receive it per the budget until we actually receive it. So it's not as if we planned on receiving it.
Okay.
Okay, does that make sense?
Is it
Okay.
50/50 as to whether we'll ever see it or not, or what's your pulse?
Well, Harvey and Irma and Maria were really devastating, and I can't imagine, considering the current climate in Congress, that we will ever see the money. But I'm a pessimist when where FEMA is concerned. This has been, what we received so far has been the fastest I have ever seen FEMA reimburse. And I to Susan's horn on that one, and staff. We all acted very quickly. Susan cracking the whip. We got a lot of money. Very short order. This is just one of those things. Nothing, couldn't have been foreseen. Okay. The only other thing I wanted to report is we received a draft audit today. It's not due until the end of October to the Local Government Commission. You all are going to have a presentation by the auditor at the next council meeting, October 17th. You will have, I have to review it. We literally received it today. So I'll review it and in the next day or two give the auditor the go-ahead to send it to LGC. And at that point, I'll give you copies of the product that goes to LGC so you'll have a chance to review it before the presentation. Okay.
Any other questions? Comments? Thank you. Thank you, Bonnie. The next is item 6, old business, the consideration of proposed 12-foot access easement for Twin Lakes Restaurant. That was an item that was discussed in closed session, and the direction was given to the attorney, and he's got to do some homework, and that we will carry to the next agenda. The next item B is discussion concerning the East End emergency access. Same results. It was an item for discussion in the closed session that the attorney's been given certain direction, and he's got to get back to us. C is the appeal hearings on Palm Cove Lot 8 and 9.
We've been,
What, that'd be Mr. Richardson?
I think because we know that the appellants wish to continue tonight's proceedings, that they should come forward and make their arguments for the motion to continue for the town council to then ask questions and discuss whether to grant it or not. Matt?
Thank you, Mr. Mayor and members of Town Council. Again, good evening. My name is Matt Nichols. I'm an attorney in Wilmington with the law firm Smith Moore Leatherwood, and I'm representing the property owners in these appeals. With me here tonight is Tim Jackson, and we are glad to try to answer any questions that you may have. When the appeals were filed, or sort of contemporaneous with that, we were working with the town, or my client's agents were working with the town. Mr. Marziano has been very helpful, and I think this is a difficult and some technical issues. I would confess they're above my head as far as I'm not an engineer and I'm not a builder, but I know that my clients want to get it resolved. We filed those appeals out of an abundance of caution just because I think there was a 10-day appeal deadline, so we had to get those filed. They've been trying to work through some of those issues. I'll let Mr. Jackson speak specifically as to some of the proposals that have been set forth, and I won't speak for Mr. Marziano. He, of course, speak for the town. But we think some additional time would be beneficial. Again, trying to get it resolved, and we appreciate your consideration in that regard, and we hope to have the matters resolved. My understanding is that the current plans may need to be reviewed by someone with FEMA. Yeah. And again, I don't speak for Mr. Marziano, but I understand that the current plans may be acceptable to him. Okay, again, I don't speak for Mr. Marziano.
You mean current plans for resolution of the violation?
Yes, sir. Yeah, I'll just call them the remediation plans. And so, again, I'm not an engineer, I'm not a builder. Mr. Jackson, if you want, do you want to say anything further?
Can we ask questions?
Yeah.
Are the remediation plans, is that putting it into such a configuration that it meets the codes and meets the standards and gets FEMA off of our back?
Yes, sir, that's the goal, is to get in compliance or to satisfy the person who makes the determination that it's in compliance, and that's certainly the goal.
Why was it done this sloppily the first time?
I think I'd like to address that. The houses were built and constructed in a manner that was acceptable to the building official on this island at the time. And I constructed it to the manner in which I was directed to.
I did the walkthrough with FEMA, and they picked it up immediately. I mean, this is a violation,
Well,
that's a violation, this is a violation.
You know, we don't need to argue about that.
the
I did it the way that I was
employee is not
That's exactly right.
to defend himself, so.
There was
that comment
there was a
proves that.
certificate of occupancy issued on the property when we finished the property, and we built it to the standards that were required of us at the time.
Wasn't it true that those people lived in that house before they got the OC?
You know, I can't speak to that. I would just say that we did what the town asked of us. We have asked for continuances. We have submitted plans. We have submitted a letter from an engineer that's licensed in North Carolina, Connecticut, South Carolina, and New York that proposed a fix. And in 25 years in the building business, I've never had an engineer's letter refused by a town official, and in this case it was.
How many houses have you built on the island? Several, right?
That's not relevant to what we're talking about, sir. No, it isn't.
This is not proper work. You know that.
Sir,
Whoa.
that is not relevant to what we're talking about. Those houses have been approved.
Okay.
Mr. Jackson, are you working with Harem now
Yes, Hiram and I are working, and he has been
to
submitted a plan to
resolve what
resolve the
FEMA
issues.
has required us to do?
That's correct, and
That's
FEMA's
what we
given us
want.
until the end of the year.
I don't know if you need all these engineering studies and paying engineers to do this and do that, but if they get together with Harem, he can coordinate it with FEMA, because we have to do what FEMA requires. They supersede us. So in essence, we have no say in this matter.
And just to bring it to your attention, Hiram has tried to get a hold of the FEMA individual that would have the ability to approve this. And not surprisingly, with everything that's going on, they've all been deployed and are unavailable. So even though he has
No,
a
I
plan
understand.
that he could submit, the FEMA individual that would have the ability to approve or disapprove of this and give him a go-ahead is unavailable because that individual, along with some of his cohorts, are deployed
Yes, I can understand that.
in several other areas that might need more attention.
You mentioned a timeline there. I didn't quite hear it with the discussion that was
I
going
think
on.
what I understand from Hiram is that we were given until about the 12th of December by FEMA to resolve the issue.
Okay, do you think you're going to be able to?
I don't see an issue with resolving the issue.
Aaron, you satisfied that this is moving apace to get a resolution that will satisfy you and FEMA?
Tough question.
I'd say there's no problem continuing the appeals for this. There's still time for them to fix the problems. The issue really is we're going through other people, trying to find other people at FEMA to consult with, other than Roy McClure, who sent the CAV letter and did the visit. They have Design and Services Division. The simple fix that FEMA proposed isn't one that they want to go after. They're trying to go after an alternative solution, and I can't just do a desk review of that. And to be honest with you, Roy wouldn't be able to either. He'd send it to these people. The people we're trying to get in touch with, we were already told to call the 1-800 number because there's no direct line to anyone at FEMA right now. But I still think there'd be enough time to resolve the plan and figure things out within the next 2 months. And then construction shouldn't take more than, Tim's told me, what? Let's say a week. So, 2 houses. So, but to that extent, I think there's enough time, personally.
And
I
right
wouldn't.
now, we're not filing anything. We're not going to get in trouble with FEMA by granting a continuance.
No, I've double checked. We're still within our rules. We gave them 6 months per our ordinances, the maximum amount of time to get this fixed, to get through the summer season, and then work on this in the fall. That was the plan the whole time. And Mr. Nichols is correct. They jumped on the appeal decision because they did have 10 days per our ordinances to file an appeal. All that being said, I've got a drawing last week, and then because of all the things that are going on, it's just, it's whenever we can get it passed up and get it sight unseen, it's going to be hard, because if we approve it at our level and they come back and do their review and say it's still wrong, this doesn't start the process over again. It just continues the process. So they're still in violation and they miss their date. And I don't want to tell them, go with what you've got right now, and then FEMA come back and say no. So we're waiting to get an okay for that before we move forward. But yeah, we've been trying to work it out. We've been in almost constant conversation about it. So it's not like this is the last, like they've finally done something now, so.
So clearly, you seem to be comfortable with the continuance?
I would, to the date they've requested in November, I'm fine with that. Past that, there's no other option. That's the thing, is that's, at that time, it is the last minute.
I was saying November or December?
Yeah, I thought December was the date.
I thought the email they gave me said the second meeting in November is when they'd like to meet.
Can you clarify the date?
So what is the
No,
second?
their deadline is December 12th. That's not when they want to continue to.
So something has to be done by December 12th, come hell or high water.
So 11/21, you want this moved to 11/21?
That's what the emails from the property owners discussed with me, I believe. I can't remember off the top of my
Our
head.
second meeting in November is November 21st.
It's a few days before. But I believe that's what the emails said. Do you remember, Lisa?
The goal is to withdraw the appeal and have it resolved. But All of that is contingent upon
You need to go to the mic, please.
the goal is to resolve the issue and withdraw the appeal.
Right.
The appeal is filed to protect the rights of the property owner.
But we could
December
put this
12th,
on
December-
the November 21st agenda.
We could, what's your
And
December?
always withdraw it if you have,
Well, that's correct. What is your December date? What is your December date for?
we're not going to wait until December.
Okay,
just not
well,
gonna
then we
happen.
should put it on October or November 21st.
That would be the latest date that we would agree to.
Okay.
Any of these violations in jeopardy of these homes?
Well, that's a tricky question. The purpose of these violations are because there are penetrating breakaway walls, and if a breakaway wall can't break away, then it's not doing its function, and therefore, yes, could damage the structure. But do I foresee any, I don't want to jinx the world right now, but wintertime floods that are going to be going over those dunes and then crash into those houses? I really don't think we have to make, because even if you hold the appeal tonight and make the decision, they're not going to have it fixed tomorrow. They're not going to have it fixed next week. It's still going to take some time. So I don't foresee an immediate danger to life and health.
Well, the reason why we're concerned about it as council is because it has a townwide implication on the FEMA rating and the ability to write FEMA insurance, flood insurance for everybody in town.
Right.
Now, is that impaired at all?
If we don't follow our ordinances, yes. Come the deadline, I'm going to start civil penalty
But
action.
we're still within the ordinances.
We'll still be within the ordinances. It'll be up to FEMA then to judge whether we're doing enough or not. And at that point, I can't predict the future of how we should handle it, but each violation is a violation, and each day is a different violation of the day. So we're talking one house, only has 4 or 5 violations. The other one has like 7, 8, 9. So,
But if there's a violation and there's a loss, there's a destruction and it's related to the violation, would they have some impact on their flood coverage?
I'm not an insurance adjuster. I can't speak to that. But as far as the community is concerned and our community rating system, this is having a detrimental effect on our community rating system. The good news is we just got measured last year. We're a 7. It should stay that way till the next visit, unless we go outside of our ordinances and don't
the
follow
next
them,
visit.
and then they'll go ahead and do a visit and then take away our CRS,
And the
put us
next
on
visit.
probation for flood insurance, and then after that, they can take away flood insurance for the
The
town.
next visit is after November 21st.
The next CAV visit won't be a CAV visit. The next visit will be when I call Roy and let him know that we've come up with a solution, and then he'll come down and check the solution after the fact it's been constructed. That's not an actual CAV visit. That's just the remainder of the last CAV visit. So,
And as from what I understand, what you said is because of the provisions of our ordinance, FEMA gives us till the expiration of our ordinance it gives us that much latitude, which is November, by the end of November.
right, and at that point, we have to institute penalties. And if we don't institute penalties, or if we vary this and just wash it clean, then we're in violation of our own ordinances, and then FEMA will institute their punishment of
Nobody is
us.
talking about doing that. All we're trying to do is give these people, honestly, the easiest thing is to give them sufficient time to make the
Right.
corrections without it ever becoming a legal action.
And don't get me wrong, even though we're in our ordinances and we start our process, FEMA will still work with us as long as they're working with us as well.
I mean, this is going on since June.
And our ordinances give a maximum of 6
Now we're
months.
asking 6 months to get this completed.
Right.
6 months. Shameful. I think it's shameful. My opinion.
I understand completely, sir.
Any, Susan?
I was just going to recommend that you might make a motion as to
I was gonna-
continuance or not.
Yeah. Is there a motion with regard to carrying this till the November 21st meeting?
So moved.
Any further discussion? All those in favor?
Aye.
Opposed?
No.
Thank you for your time.
Thank you.
Thank you for your time.
Next item on the agenda is D, the Metcalf Drive roadway.
No, I don't. 7 months.
Is it my turn to come up here?
Yes.
I hardly know where to begin. I got shut off last time, 3 months ago, from a motion to look into the annexation to make sure it was properly done, which I had no problem. I wasn't here to argue that. I wasn't here to even bring that up. But somehow it got brought into the argument. And I suppose that Ms. Parker now can tell us if we were properly annexed or not, which has nothing to do with the issue that I'm trying to present. If you just let me finish, last time we could have gone into this. Mr. Richardson has sent me a letter. He has told me that we have a private road and that therefore the town cannot take it over and cannot make it available to maintenance and repair, right?
That letter was August of 2015.
Yeah, somewhere in there. I've got so much paperwork on this as well.
Okay.
But anyway.
Mr. Lewis and Mayor and members of council, my letter from August of 2015 to Mr. Lewis was not that the town couldn't take it over. It was that the town, if there's an offer of dedication made and the road is in compliance with the town's street standards for a public street, then the town could decide whether or not to accept the offer of dedication. The mere fact that your area was annexed with a private road doesn't make it a public road and doesn't require the town to accept it as a public road unless the road is brought up to town standards and an offer of dedication is made.
Let me cut through some of this for us, okay, so we don't get strung out on all these technicalities. When I started this 13 years ago, I had no attorneys to go to. I had no case law to go to. I had nothing other than the town attorney telling me that they would not take over our road because it didn't come up to DOT standards. There was nothing of it. It had nothing to do with whether it was private or public. It was just that it was not brought up to standards. Well, I let this thing go for several years. I didn't have another word to say about it. I knew I couldn't bring it up to standards. But in an article I was reading a few months ago, I found that Jason Kay, senior staff attorney with the North Carolina Institute of Constitutional Law, wrote, and I quote, "A municipality must provide substantially similar service to annexed residents as it provides to other residents." He went on to say that the services must be provided on a non-discriminatory basis and they must be meaningful. He went on to cite two cases which I have presented to you, Nolan versus Ryan and also Dunn versus the city of Charlotte. These are case laws, sir.
But the point you're making is that you're not being treated the same as places with regard to the road maintenance, as places that were within the limits of the town when it was annexed, when your street was annexed, or the territory in which your street is located was annexed. That's your argument, isn't it?
No, my argument is that you're taking taxes from us on an equal basis with everybody else, and you're not providing the same services. That's my argument.
Well, let me tell you what I did. This has come up a couple of times. I went through all the records in the town about the annexation. The annexation, this is a 2005 annexation. I prepared notes as to what the annexation consisted of, chronology, what the annexation report said. I then prepared a memorandum for record to go into the town file so we don't have to keep reviewing this every so often. And I want to read it. Metcalf Drive is currently a private street not improved to town standards, which is not now nor never has been maintained by the town, and which is located within an area which was the subject of annexation by the town in 2005, which also included Lakeshore Drive, Gate 1 Sea Trail, Gate 1 Oyster Bay, and Woods Court. During a council meeting in 2017, Dwayne Lewis, the resident of Metcalf Drive, raised the allegation that as a result of the annexation of the property, which included Metcalf Drive in 2005, and the entitlement of property owners on Metcalf Drive to receive the same municipal services rendered to all parties within the town's existing boundaries, requires the town to maintain this road. In addition, he alleged that in conversation with him, Mayor Ron Klein stated the town would maintain the roads in the area being annexed. Mayor Forrester reviewed the town files regarding the annexation and prepared notes on Metcalf annexation, setting forth a chronology, synopsis of salient portions of the annexation report upon which the annexation was carried out, and the ordinance of annexation adopted May 18, 2005, and advised that in his opinion, the annexation was carried out within the requirements of the then existing statute. A copy of the notes is attached. Mayor Forrester also had conversation with Mayor Klein, who denied any statement to Mr. Lewis that the town would be accepting responsibility for the maintenance of Metcalf Drive. In addition, G. Grady Richardson Jr., attorney for the town, wrote a letter to response to Mr. Lewis dated August 12, 2015, addressing allegations that favored the town to maintain Metcalf, violated a state statute, denying the allegations made by Mr. Lewis of illegality as factually and legally incorrect. A copy of that letter is attached. A review of the town files regarding the annexation shows that the then applicable statute was complied with fully. The annexation report adopted and made public as part of the annexation procedure references the enabling statute requirement for provision of municipal services to be on the same basis that it provides within its existing boundaries. Page 21 of the report under major services clearly sets forth that the town would only accept the streets after it has been established that the streets were built in accordance with town street ordinance. In addition, on page 22 of the report, the summary of revenues and expenditures showing how the annexation would affect the town finances and services under expenditures shows street maintenance as $0, evidencing no anticipated expenditure by the town for street maintenance. Before, during, and after the annexation, the town did not accept private streets or responsibility for the maintenance or for their maintenance unless they were constructed in accordance with the town street standards. Before, during, and after the annexation, there were and are private streets within the territorial jurisdiction of the town that were not accepted by the town and for which the town has assumed no maintenance responsibility. In addition, in order to have the town accept responsibility for maintenance of formerly private streets, some property owners, through their homeowners associations, have paid substantial sums to bring some of their streets into compliance with the town street standards at their expense and not of the town. A number of those streets existed when the areas in which they were located were annexed and includes streets in Seateal Plantation and Sandpiper Bay. The residents on those streets and in those areas pay municipal taxes and continue to be responsible for the maintenance of those roads which do not meet town street standards. Based upon the foregoing, it is clear that the residents on Metcalf Drive are not and have not been deprived of municipal services in regard to the maintenance of Metcalf Drive, which have been and are being provided to other residents within the town boundaries.
Everything you say is true, except for one thing. You're still taking our tax money and you're not distributing it equally.
How are you being treated any differently? How are you being treated any differently than residents in Sea Trail and Sandpiper Bay who are maintaining private streets?
Well, I don't know about Sandpiper Bay. I know that they did put money into their subdivision and improve their roads so that they could be, and so that they could get your municipal maintenance and repair. I know that. I don't know about Sea Trail. Maybe they don't want to have you in there doing their maintenance and repair. I can't answer that. But I can answer this. I've got a statement. I've got it. I got it from the Homeowner Association. They have dedicated this road to you and given it up as a private road. They're giving it to you as a public road. Secondly, I've got a petition here with 21 signatures on it. That represents about 90% of the people on Metcalf. The others I couldn't get because they were either out of town or they didn't answer the doors, whatever. But they want this road maintained by the town to whom they're paying equal amounts of taxes. And that is their gripe, and that should be available to the people in Sea Trail. And however it got out of hand with the other folks over there, I don't know. But you got to be fair.
Mr.
If you're going to
Lewis.
take taxes, why don't you distribute them fairly?
Mr. Lewis?
Yes, sir.
Did you go to the beach, the town of Sunset Beach this summer?
I was over there a couple times.
That's using the town's roads that have to be maintained. We're providing you police, fire protection. the taxes go to the overall welfare of the town of Sunset Beach. If you and the 21 petitioners want to go and build that road up to standard for the town to consider an acceptance, the town council will take it up then. Until your road is up to town standards for accepting a public road, it's not going to do so. Because then it would be treating you unfairly versus everyone else who has a public road that was offered for a dedication and acceptance. Your road is not up to standard. You're using the town, you use the town's roads to get here to this meeting tonight. You're using the town's property right now to be present for this meeting. That comes for a price. The town's not denying you services. The only thing the town hasn't done is accept a road that is not up to town standard. You can make an offer of dedication. Town doesn't have to accept it. As of right now, the town's not accepted it. That's the law.
So what you're saying is then that these cases that were brought up and have been adjudicated
Are not applicable.
are not applicable to Sunset Beach?
Correct.
Okay.
No,
Brian,
no, to your situation.
Do y'all agree with that?
Yep.
I'm not an attorney. I don't have the background, or I don't even claim to have any kind of legal sense about me in some time. But the thing about it, this whole thing is it's unfair.
We understand your position. I, as counsel for the town of Sunset Beach, respectfully disagree, and that's not the legal standard. Again, if you want to go pave the road and bring it up to town standards for a public road in the town, for the town to maintain, council will consider it then. At least that's my advice. Right now, it's not ripe.
Well, the road can never be brought up to town standards. If town standards is going to go by what you call the DOT's criteria for roads. DOT's criteria for roads is so far beyond what is 90% of the roads that you maintain right now that I don't know how you can hold this standard to us. I don't know how you can hold that to us. In fact, you need to offer this maintenance and repair to everybody that pays you taxes. They pay equal taxes to you.
But one of the reasons why the town can't is it's unfair to all the rest of the residents of the town. Because if your town is not up to the correct construction standards, the cost and repair and maintenance is going to have to be borne by all the other taxpayers in the town, not just on Metcalf.
Well, Mayor,
And that's why the requirement is to bring it up to the standards before we accept it.
All due respect, Mr. Mayor, it's never going to be fair as long as it's administered this way. Policy 98.18B was written somewhere in somebody's dark room to put a tax grab on people through annexation and then take their tax money and do something else with it.
But
That's
you were
that's my
using-
take on it.
Mr.
It
Lewis.
was not fair. It could never have been a fair policy.
Mr. Lewis.
Yes, ma'am.
You're using town services. You used them tonight getting here. You used them when you went to the beach this summer. You used the bridge that takes you over to the beach this summer. You're using the town services right now. You're not being deprived anything.
Maintenance.
Maintenance of the roads. And we only get state funding through POW bill funding for roads that are up to state standards for us to accept.
Are you sure about that?
Yes, yes.
Are you sure about that? Because there's roads that are not up to state standards that you're getting POW bill funds for.
Yeah, I thought this issue was a simple one when they annexed you or annexed your area or Metcalf Drive, that you claim that someone in the town said that they would take care of the road.
I'm not going to get into a contest with Mayor Klein. He's an older man, and I understand he's not in that good of health, and I don't know what he remembers and don't remember, but I'm not going to get into that. But I can tell you what I was told.
This doesn't just include Metcalf Drive. It includes Lakeshore Drive is in exactly the same position. Gate 1 and Sea Trail is in exactly the same position. Gate 1 and Oyster Bay is in exactly the same position. And Woods Court is in exactly the same position because they were all part of that annexation. And they're all private roads.
There's a total of 21 roads, according to Mr. Grady Richardson, that are not being given maintenance. they're in the same boat as I
The
am.
only thing that I can please you with, Mr. Lewis, is the fact that the town of Sunset Beach can no longer force the annex.
That's a- Yeah, there was an annexation, what do you call it, frenzy going on back in, what was it, 1980, 1989, somewhere. And a lot of this was done. But I'm reading directly from case law here.
But well,
They got it says that the state statutes in North Carolina don't allow you to do it.
there's nothing.
And that's my point.
There's
and that's
nothing
it.
that either Mr. Richardson or myself is going to say that's going to convince you otherwise. You're setting your opinion regardless of what the
It's not
rationale
my
for
opinion,
it is.
it's the appellate court. This
yeah.
went through the appellate court, sir.
Is there
I
any
don't
other,
know- I don't
any
know how
other
you can
comment
deny
or questions from council? Okay. Thank you, Mr.
Okay.
Lewis. The next item on the agenda is consideration of the ordinance amendment for Article 6, Section 6.06 HBB1. Okay, please, if you want to have a conversation, please step outside of the room because it distracts from other people's attention. It also distracts from council people's attention. So if you want to discuss anything among yourselves, please do step out of the council room, please. All right, this item is the rezoning on in BB1. The planning board, it was taken up by the planning board. I'm not going to read their report, but in essence, the recommendation of the planning board was that there be a denial of any rezoning in the BB1 as requested. That historically what happened is as best I can determine, is that the UDO ordinance, the zoning ordinance, established did not establish a density for a BB1 zone. And in 2015, there was an amendment to the BB1 zone that did establish a density requirement of 21.7 units per acre. And
my understanding is that we had a density of, what, 35 point something?
well,
The way the old calculation worked, it didn't declare a specific density. It worked off base of square footage of the blah, 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 and they cleaned it
Anyway,
up
so-
with this amendment. But equivalently, it came out to like 38, 39 in the past.
And I don't think people had focused on that until somebody came in with an application for
Text amendment.
No,
Oh.
an application to build
Yep.
an apartment complex, basically.
Right.
And the density was high enough where people said, oh my God, this is not what we thought we were going to be seeing in this area.
Mhm.
At that point, unfortunately, after he went to the Board of Adjustment. After he got that, Town Council finally passed the amendment reducing the zoning to 21 in compliance with what's exists in the rest of the town. This is no different than the zoning in the rest of the town. The particular circumstance now, anyway, the reason this is here before us, why don't you talk about that?
The applicants wanted to build a 4-unit like the rest of them on that street.
27th Street is in the commercial area and has been almost built out with 4
Quad
with
units.
quadplexes on that street.
Right.
One of the lots, the owners of those lots had a permit to build the same structure on a lot sandwiched in between the rest.
Mhm.
He sold that lot.
Well, he got his he willingly revoked the permits when he requested his money back for the development permits.
that permit
and
went
then they
away.
sold the money. I mean, they sold the property.
Right,
And then
and-
the new owners,
Are
When
now
he-
subject to the new ordinance.
When he
Right.
revoked his his permit so that he could get his refund, we had already at that point enacted the new
yes.
requirements for a lower density. He sold the lot, the purchaser, for some reason, didn't know that the density had been reduced and wants to build a quad building in the middle of the rest of the buildings.
Mhm.
My concern, council, is that there was a reason why the zoning was reduced to 21 point something per acre. And the reason is that that was just, the people realized that that high a density makes no sense at all in the commercial areas. Too much of an imposition and a burden on the island and the island infrastructure. I am concerned about whether we can legally or not allow this person to build a quad. Is it really in the best interest of the town of Sunset Beach to allow that? Even though, you know, maybe he could have a year ago, maybe the original builder could have. Do we want that to occur? And there is a difference of opinion on council. My personal opinion is that the density was reduced for a reason. You can certainly build a conforming building that looks just like the rest, but that has 2 units in it instead of 4. The idea is to get the density down. We're not getting that density down when we allow another quad structure. So that's my concern.
Hiram, may I interject? Is this an applicant-initiated text amendment or zoning amendment, or is this a town staff-initiated rezoning?
This is a citizen, the applicant initiated.
Is the applicant here tonight to present arguments in support of its text rezoning amendment? The applicant's not here. I'm unaware of any motion to continue tonight's deliberations. I'm happy to talk about whether or not you can lawfully do this rezoning in the context of these circumstances if you wish. But since it's applicant initiated and the applicant's not here, I don't believe the town council should get engaged in the business of doing the applicant's business.
If I may, real quick, also, just for terminology's sake, this isn't a rezoning. It's just a text amendment, so they can do something in that zone.
But the problem is if you did this text amendment, then anybody in that zone, you go
Right, but I just want to point out.
Right back to 35, whatever is per acre, and we're saying.
Right, but I just want to point out.
I think the general agreement is absolutely not. We're not going back.
Right, but I just want to point out that there's separate issues. That this isn't rezoning. This is changing our
Well,
ordinances.
how do you distinguish between rezoning and text amendment?
Rezoning would actually be changing the map to a different zone. It's still staying BB1.
They're talking about changing the text on the density.
They're just trying to change the density in
Changing the
BB1.
requirements.
So I just want to point that out.
The requirements of the zone.
That's my fault.
There's multiple things going on here.
Using rezoning.
But I believe some previous conversation was trying to find a way without doing the text amendment that they could still have vested rights to do the building. And I think that's where some of the overlap confusion is coming from with
Yes,
rezoning.
and-
That's not, for the sake of this thing right here, is just they want a higher density. Our land use plan calls for 21.7. That's why that number was chosen, because it was in the land use plan. They wanted a smaller density. They went with what was in the land use plan.
Well, Hyman, I agree with Attorney Grady. If he's not, the property owner's not here to defend himself, we shouldn't be fighting him for his rights. And I was for him building the property. I'd like to make a motion that would deny cut it.
All right, before I call for any more discussion on it, in view of the statute change that took effect yesterday, we need to be specific.
Actually, in review, the only statute change actually that did occur was that if you want to do this and it goes against our land use plan, we have to amend our plan at the same time, which I will go over in a later workshop when we talk about land use plan, why that complicates things for coastal counties. We can't actually legally do that because we have a 30-day criteria to notice to change our plan. But so we're still fine to reject it based on the fact that it's not in our land use plan. That language has never changed.
But I understood, and I, obviously I can be corrected, but I understood that the statute required on a denial of the change, you have to state specific reasons.
And in this case, it's stated for us, it's not in continuity with our land use plan.
And that as I read it, that's not sufficient. You've got to give specific reasons why it's not. Am I wrong?
The land use plan specifically states they want to have 21.7 density in these areas. The way they went over at my conference last week, because this was a major issue, was specifically that if you call out your land use plan as your reason and state it, you can verbatim it if you want to, that's sufficient. We're not making, it's covered in our land use plan. If we had to deny it and it wasn't covered, that's where we'd have to come up with really specific statements.
The School of Government, talking about the new statutory requirements, it says,
You're correct, Mr. Mayor. There needs to be a statement by council rejecting the proposed zoning amendment and describing its inconsistency with the town plan.
it just
Which
can't
is
say,
statement in this-
you can't say it's just inconsistent.
Right,
Okay,
but that statement's already in your packet for y'all to read.
It's already in here for the, okay. May I?
The planning board has said that the proposal's
With your
not
motion,
consistent with,
Bob,
yeah.
I move that we uphold the recommendation of the planning board denying a request to change the density from 21 to 35, because we need to protect the existing community character, scale, and infrastructure capabilities. Our policy is to reduce the to continue the currently allowed density for multifamily structures, and that is in the best interest of the public.
In my opinion, that would be sufficient. That's specific to delineation. That's what I was looking for.
All right.
That's why we put these statements in there for y'all
So
to
now
read.
there's a motion on the table.
Everybody understand?
Yep.
Okay.
Absolutely.
Any other discussion? All those in favor?
Aye.
Opposed? Thank you.
Thank you.
The next item is discussion concerning Chapter 99 Park Rules, Use Fees, Schedule, and Wedding Policy. Susan?
Yes, I was wondering if we could pull Grady's item, the conflict of interest, before we start on the Chapter 99, so we can get him out of here.
Are you talking to me, Susan?
Well, you're in the general area. It is your item.
It is,
but-
and I have not seen the modifications yet at this time, and I'd be more than happy to carry that forward so I have a chance to see the modifications along with the council. Is that?
So with respect to the draft conflicts of interest policy, there were 12 numbered paragraphs.
That's correct.
Councilman Serrato had no objection to 1 through 11. I don't either. He then pointed out an apparent inconsistency with the language in the draft of 12, and I have drafted new language. The only change I've made, or the recommended change I've made, is to the language of 12. If you've not seen it yet, then you can certainly
I haven't seen it.
punt it over to the next meeting, or I can come share it with you now if you'd like.
Could you share it?
Well, I changed the whole.
Yeah, why don't you punt it, because I think the entire council should see it.
Can you read it?
I can read.
Thank you.
So the old.
The old one.
The old 12, that's what I'll call it if I can find it. I just had it.
The old 12 says, fulfill your statutory obligation to vote on all matters that come before you, even when there are appearances of conflict, and only refrain from voting when there is a legal basis for being or a requirement to be excused from voting.
Right, so 12 seem to be saying that even though for points 1 through 11, we're talking about appearances of conflict, et cetera, you're
Right.
still in 12 saying you can vote in the appearance of a conflict.
Right.
So what I did was change the language as follows. My recommendation would be, fulfill your statutory obligation to vote on all matters that come before you, and only refrain and be excused from voting when there is a lawful basis for doing so, as approved by a majority vote of council. The requesting member must make his or her request to town council, provide all grounds that he or she believes constitutes legally and factually sufficient reasons for council to approve the requesting member's recusal request. Council shall then decide by motion whether to grant or to deny the member's request to be excused from his or her statutory duty to vote. If the member's request is denied, then said member shall cast his or her vote for or against the question presented.
I want to say something on this, Rich, very briefly. There are conflict of interest legal requirements by state statute. We have an ethics policy that the town passed. Honestly, I don't see anything in this conflict of interest policy that's going to add anything to what we already follow and what we already do.
Do any of
And
the other
I just don't
communities
see
have
the
this kind
point
of?
this at all.
If I could, I was gonna add, Susan was directed to get conflict of interest policies from, and you used the term of art. I don't remember.
Yes.
Look at something to.
Listserv.
And there are none.
And
Most communities have adopted, as per the requirement of state law, a ethics policy, not necessarily a separate conflict of interest policy. So what I did was, as the staff report states, is I looked at the UNC School of Government to see what they had that was outside of the actual ethics policy that we've adopted. Most communities, and I couldn't find anyone that would respond or could respond, do not have a separate conflict of interest policy, which is why we put together what you were given based on criteria that was outlined in a School of Government document.
Which we already follow, we've been following, and Rich, I think the problem is that you think that there are conflicts of interest that maybe the rest of us, or some of the rest of us don't think are conflicts of interest, certainly don't meet any criteria, legal obligation to be a conflict of interest. So we're following the law, we're doing what we're supposed to do, we have an ethics policy. A conflicts of interest policy as written is not going to add one thing to what we currently do.
If I can add to that,
Completely unnecessary.
I've got two issues with it. One, in keeping with what Carol said, is I think it really muddies it up and provides a source of substantial contention when you have existing things that, resources that Susan was referring to, that I went through, I think it was the August or maybe the first meeting in September, the difference in the different statutes. I think it's a mistake to codify a conflict of interest on a local basis, because you're going to be fighting about it forever. Does it fall in this? Does it fall in that? Does it fall in the other provision? Where your resources are really the School of Government, which is really just an opinion, it's not a law, and what the statutes say. My second problem with it, with the language as it's prepared, is it makes reference to statutes that are inapplicable. It refers to 153A, one section of which has been repealed. It refers to the only sections, the only chapters that it refers to, where it refers to 160A in the language of the proposed language, deals with zoning and deals with, 160A 75 is the voting paragraph where it says in municipality, you need the consent, or if you don't get if the rest of the council doesn't agree or the board doesn't agree, it's considered an affirmative vote. I bored to death a lot of people with my rendition when I explained the conflict of interest situation with different state statutes, and I'm sure I did. And the 153A and the state ethics standards clearly apply to state employees. One of the things that's not in here is in the contracting statute, if you're in a town of under 15,000 people, none of this applies. I used that as an example in my last discourse about it's designed because North Carolina has so many small municipalities, where that's why it's considered an affirmative vote if you don't vote. I use that as an example. So some of these, and I've read every one of those statutes that are applicable here, and as I said, the only reference to municipalities is zoning and the obligation to vote, which is statutory, and the others are all county, and they don't include things like the $15,000 limit on threshold for zoning. Population. 50,000 population for zoning. But I just think you're making a mistake to try and codify it on a local basis. I really do.
Well, I don't know why, and I disagree. And there's nothing in the statute that says that we can't have our own conflict of interest policy. If this council wants to defer this, I'll let them, but I would like to file a motion that we accept this conflict of interest policy and consider it a start. And if you recall, when I was mayor, I would read a conflict of interest policy before each meeting. And when Mayor Watts was elected, that was discontinued. I think we have to resensitize ourselves. What is a conflict of interest? Because everybody seems to have their own interpretation. And the rules and guidelines that have been presented to us at least does that to me as a first step.
I
We
agree
have
with
to
It's not
maintain.
doing anything more than what we currently follow.
I agree with your statement that everybody has their own concept, which is the genesis of my recommendation that you don't codify it locally, because you're going to argue about this every single time you're going to have a controversial vote. You're going to argue about it because everybody has different perceptions.
Well, that hasn't been proven yet.
Well, I'm telling that's what's going to happen.
I'm not so
All
sure.
right, so you made a motion
we
to
have a-
adopt.
I made a motion, Mr.
We have a
Mayor.
motion, let's take a vote.
No, we're still discussing it.
Yeah.
Okay.
People have.
We have
Sorry.
a code of ethics that's been in existence since 2010. And we have a clear process that if we have a question or a concern or think that we have a conflict of interest, we take the facts to our town attorney, and he gives us his opinion. You know, I fall on the side that we don't need this policy because we're well taken care of as it is now.
I do agree with Councilman Serrato in the fact that about the inquiry at the beginning of the meeting as to whether any conflicts exist or not. And I don't think we need a conflict policy to do that, but I agree with him.
No, we can do that without writing a new policy.
Well, that was a separate motion I was going to make.
Any
Mayor?
Would that motion make you happy, Rich? Just to make that motion?
I can't hear you, Mark.
At the beginning of the meeting, have a conflict of,
Yes, to have the mayor read a statement,
right.
asking each council member if
If
they,
he puts that in.
But he's
that's
asking you
separate
in lieu
motion.
of a conflict of
That's a
interest
separate
policy.
motion. Well, we
Lieu of
already have a vote.
conflict of interest,
Well,
Rich.
let's vote on the conflict of interest policy and then discuss that.
Well, I still think.
Susan?
Hi, Rich. You need to, if you wish to, amend your motion to include the recommendation you received.
yes, I would.
Okay, so we have, the motion on the floor is to adopt this policy
As
with
revised.
the revision, attorney's revision. That's the motion.
That's the motion, including,
As a point of discussion, Mayor, we have the opportunity right now, as a part of our rules, that any council member that feels is a conflict of interest is occurring, potentially, that they can petition the other council members to have their vote, did not vote on a particular item. And it would then not be taken as a yes vote. I think we need to respect the council and allow that to guide our process.
All right, any other?
All of this is in our council rules.
I know, it
in
already
our-
exists. This already exists.
Right.
All right,
Code of ethics.
we all understand what the motion is to adopt this proposed conflict of interest with the revised language. All right, that's the motion.
As amended with
With his, with the
item
attorney's-
12.
Well, with his language, what he read.
Absolutely.
All-
Thank you, Grady.
Okay, all those in favor?
Aye.
Opposed?
Nay.
All right, we need a, I can read it anyway, the paragraph about conflict at the beginning of the meeting.
We don't need a motion for that, do we?
Yeah.
No, we don't.
Well, we make a motion and it's nothing's.
Put it in the record, make it
let's-
official.
We'll spend 20 minutes arguing whether we need a motion or not when we can get it done. You want to make a motion?
I'd like to put a motion in, for every meeting we make that announcement, conflict of interest.
Any further discussion? None appearing, all those in favor?
Aye.
Aye.
Opposed?
This is the motion to announce.
Yes.
Thank you. Thank you, Mark.
All right, the next item on the agenda is, we're going back to the park rules.
Thank you, Grady.
Bye, Grady. Drive safely. No speeding.
Now, I think the council all understands this, but for purposes of the public in our discussion, I want to distinguish what we're talking about here. There's basically 4 documents that are under consideration. One is the ordinance, which is Chapter 99. One is the park policy. One is the fee schedule. And one is a wedding policy. And then there's a fifth that really is the attorney generated on a,
There's
what do you
actually
call
one
it?
more that didn't get any of the special event rental permit application, because there might actually be some changes there too.
All right. Let me start with the ordinance. Chapter 99, which is entitled Town Park Regulations. There was a proposal, so the public understands. Councilman Scott, Councilwoman Scott, made suggested changes to these documents, and that really only related to the ordinance. Councilman Larkin made certain written suggested changes. I took those to the existing documents and made certain changes and put them all together in one document. It's hard to read, they're color-coded, but if it wasn't copied in color, you wouldn't know who did what. But we haven't had a chance to discuss, the council has had a chance to discuss collectively all the suggested changes. Now, the attorney has suggested language changes to the Chapter 99, which are really not substantive. Does anybody?
All right, so going through this thing, it has gotten so confusing at this point, with so many changes and more changes from Grady, that I would suggest that we do a new version with the changes marked by Grady and what you have in there, but let's have a discussion now. There are certain things I think that have not been addressed or that we may want to change or talk about. So to give you direction, to have those changes incorporated also, the first area would be the actual fees. And I think there's some disagreement on what those fees should be. On the fee schedule, I think it's just about there, but I would like to see, for a high-impact event, the fee go from $150 to $200. That's what we originally had in there. I don't know, somewhere on the line it got, Susan, you changed it to $150. I would change that one fee back to $200.
So for purposes of public information, on the fee schedule that was adopted, that existed, there was no use fee. There was a $25 application fee for a special use permit, but there was no use. And I think no use fee. And I think the council all individually believe that there should be a fee for use. And we may disagree on what that should be, but but we all agree there should be a fee for use, and that's what you're addressing.
Yes, so right now, I think the fee schedule is fine. I propose that we change, for a high-impact event, that we change it from $150 to $200. We could take a vote on that now. So
Can we-
if they
can we
have that
discuss it
direction-
first?
Yeah, we can discuss it, and then anybody else can make.
Yeah, after discussion, of course.
You know, I've been thinking about this quite a bit, and one of the areas that I really run into problems is what are we trying to attain or to accomplish with the fee schedule? I do think that the current fees for the park usage are not adequate. You know, and it was very low. There really was no rental fee for the park. There was an application fee that went into that. But part of the question is, you know, so what are we trying to do with it? You know, I think one of the things that if we do have a fee structure in the park, one of the things that it does is it causes potential users to think what they're going to do in the park and why, and it kind of filters out by having a cost involved, sort of, if you will, spurious events. Somebody who wants to just leave it at spurious events. But if we do pull in the money, my question is, what are we going to do with the money? I mean, we don't have a fund that's for the maintenance of the park that I'm aware of. The fees would just go into our general fund. I mean, so it's not like it's going to go into a park improvement program that's there. And the best that I can discern, the activities in the park at this time do not cause a quantifiable addition to the amount of work staff has to do or the work on the maintenance of the park as it stands now. And I'm happy to be corrected if that's it. So what are we doing with it? So with that background, I kind of propose a two-part structure. What we have in a fee structure now is that was proposed, it was $10 for a minor impact, 100 for a medium impact, and 150 for large impact. I think works very well for a single day event. Obviously, what we have and what's been a big part of the contention here has been events that have taken place one day a week over a period of time. The only one that's doing that is the waterfront market. My proposal is not to set a fee structure at a point where it will chase the market away or cause an undue burden on them. But we should raise the rates. So my suggestion is we set I'm calling it a multi-day event. That's once a week for a period of time. A flat fee for an event with 2 to 10 iterations of somewhere in the nature of $500. And for an event that goes beyond that, somewhere in the nature of $750. I mean, just using for comparison, Ocean Isle Beach charges $350, charges the waterfront market LLC $350 for the season. Sunset Beach didn't charge anything. Sunset Beach charged $25 an event for bathroom cleanup. Over the 24 events, it came to $600. There was a cost sharing with the POA on Porta Johns over at Ocean Isle, so they're both roughly balanced. My point, if we came up with this subjective rate for the waterfront market, it would come out to $750 a year plus 600 cleaning fees, and it would come up to about $1,350. If you go $100 a day, it comes up to, with cleaning fees, $3,000. You go $150 a day, it goes up to $4,200. Again, we're not putting that into a specific fund to maintain the park. So my question is, why are we being compelled to charge what I think are high fees? Now, I think we should charge fees. Obviously, the fee rates would be subjective, and I think a two-part structure on the fees would enable us to encourage events to the park, you know, people clearly like the park, has been well received, public opinion has liked the park and has liked the market that's in the park. So I
Kind of
don't
real
think we
quick-
should I don't think we should set a fee structure that will deter these types of activities.
All right,
And
let me
I'm
cha-
afraid we will.
Let me try and channel the discussion here. We've got two proposals. One is to, on a per person basis, a fee, graduated fee on a per person basis
day.
per day. And Councilman Corbett has suggested one event fee higher than the per day fee, but if you did it on a per day, it would be less than what it would be per
Two-part
day.
structure.
So that, conceptually, I'd like to deal with that concept.
No, Bob, no. Carol first said the fee should go up to $200. That's what should be talked about first. And I think that's correct.
Well, no,
You have-
yeah, but well, I mean, he's raised the issue. All I want to do is find out which way you want to do it.
Well, I'm telling you, as a councilman, I want to go with a $200 raise.
And I offered an alternative because I think
agree
it's
with
too
that.
high.
Just disagree with you, John, that's all. On the other ones, I agree with you, but on a major impact, $200. You take, for example, the farmer's market, that's only 10 merchants. They charge $20 a person, so that's only 10 people that will impact that market, 10 people. They do 60
You're saying
vendors.
he's saying the
So
break-even,
they
the
do 60 to
break-even
70
point is
vendors
to
a
get
day.
10 vendors.
Not all the time, but on average, I went there 5 weeks in a row, they do 60 to 70 vendors. For us to charge 10 vendors $200,
No, we're not
I'm not charged, I know. But the thing is, that comes out of their kitty, the LLC. I think they could afford the $200.
Look, the reason I'm suggesting $200 is, I'm not looking at the farmer's market, I'm looking at a major impact event of 150 or more people, which is a lot of people in the park. If you think that we're not incurring employee costs, you're wrong. People walk in the areas, things have to be resodded, you've got landscaping requirements, you've got mowing, you've got bathroom charges, extra water charges. That bathroom fee doesn't go up based on 150 people or more. And in terms of whether or not it goes in the general fund, I had suggested, and Pete and I we had a language in there that said something about keeping it in a separate fund, which could do additional things for the park. It could
Carol-
purchase an additional swing. It could
Carol-
make improvements that otherwise we wouldn't normally take care of.
Carol, the reason that I'm not in favor of setting up a park fund, if you will, because then that fund gains money. And once there's money in that fund, then as human beings, we're going to say, let's spend that money on the park and maybe do things that we don't need. I think everything needs to take its position within our town and as
All right, so
as one unit.
that was one
Now,
of my questions. Does
I-
everybody agree? Do you agree with Pete on not having a separate fund?
Well,
I'm
So-
gonna ask Bonnie Braid to come forward.
I know it's not required, that doesn't mean we
That-
couldn't.
It's not,
not
Bonnie?
allowed?
it's,
That answers that
there you
question.
go.
Okay.
Very
Yeah,
simple.
I didn't
That
think
goes
it was
out.
required. Now, also,
Pete, can I ask Susan one question about the fee? How much do we bring in now, about 4,400 with the application fees? I think, yes, all right, 4,300,
1,700 of that was from
the running. Okay.
well, and when we have things like the Paddle Fest, the fire department's charge because they have a boat, there's other things that skew those charges. The waterfront market doesn't need the support of fire department. And that's, I don't even want to go down that road, Mark.
I agree. I
My-
mean,
my-
I really wish I didn't even bring up the.
Our
Okay,
point-
we've got the resolution as to separate fund.
All right.
Okay, now.
My
now-
point is that it shouldn't be a profit center. I don't think that's our intention, to make the park a profit center.
I
The-
agree.
The intention is the park is to have reasonable activities that our citizens want and can enjoy, and to enhance the style of life here in Sunset Beach, which I think the waterfront market enhances that.
All right, now we
I'm
have
the one that
200
I'm the one that suggested the $150 for the, call it a high impact event. And really what we're saying, it's not high or low impact, it's, we're doing it according to head count. And we're assuming that 150 people are going to be more damage to the park, if you will, more impact to the park than 50. And that isn't necessarily the case. It depends on the type of activity and the type of people that are there. I'm sure that a wedding with a tent in the middle of the grassy area does a considerable amount of upkeep required by our Department of Public Works. I think we need to simplify this thing, though. I hear what John's saying, and there's some merit to that. We got to this point right now with the waterfront market because we didn't realize how popular something like that was going to become and how much our citizens were going to enjoy that and benefit from it, and the quality of life and how it would attract visitors and da-da-da-da-da. So we don't need to make a document right now that is going to withstand the test of time forever. We can tweak this as we move along. If we see, we've got one event now that's a repeating event. It's the only one we have. To set up a whole fee schedule just to deal with a repeating event, i.e. the farmer's market, I think is making this more complex than we need to.
It's
right
not
now.
just, it's not just the farmer's market. There are other events, there will be other events. It's time, we need to look at this now.
Well, we're charging them $150 a day.
Well, I had 200, you changed it to 150, let's take a vote.
Guys,
Where we
you
wanna
guys,
go. It's very
as a council,
simple.
can one time meet in the middle at 175?
I still would like
Just
somebody
one
to
time?
kind of answer.
That would be, I would do that.
Why is it that we need to charge so much money? What are we getting out of charging the money for? Because the weekly maintenance in the park,
I think the-
is pretty consistent as to, you know, whether or not we have a waterfront market in there in terms of going
don't-
through and
Right,
cutting the
Rich
grass,
has
et
spoken.
cetera.
Mr. Mayor, if I may,
God, this is just
and
the
I've said
first
this to each of you so many times, I don't care if it's 150, 200, 175. The only thing that I know is that I asked Susan, and she gave me an estimated cost of what it costs to maintain the park. The reseeding that would have to be done due to heavy usage and other maintenance kinds of things. We're not here to make money. We're here to recover expenses to maintain the park. That's a $4 million investment. And we also have to try to limit usage, because we don't want the park to be filled and used every day. This park was built for the citizens, And I have heartburn when I think this land, this public trust land, is being used for profit organizations. That troubles me greatly. It's public land. It's public
All right,
land.
let's limit our comments now to the
Okay.
fee structure,
So,
okay?
as far as the structure, if it's 150, 200, I'm not going to argue about it, Bob.
All right, then,
Can we make a motion, Bob?
does anybody want to have anything more to say on those? If not,
I make a motion.
make a motion.
I'd like to make a motion to compromise for John, make a $175 fee for high impact.
Replace the suggested.
That's not a compromise with me, sorry.
Well,
What's your?
That's a compromise with me.
And me.
Me too.
To replace the 150, to replace the 150 for over 150 people per day to 175.
Correct.
That's the motion. All right, all understand the motion? All those in favor?
Aye.
Aye.
Opposed?
Nay.
Okay.
Okay. Next issue.
Oh,
No,
you're right.
sorry, this
she's
is
right.
not a final thing on what's going to be passed. All we're doing, we're voting to
No,
give
she's-
direction to Susan and Lisa in terms of revising what will then come before us.
No,
This
I,
is- We've got to give them direction, because we can't, this is not going to continue for another 4 months.
It's a-
This is ridiculous.
it's a vote to put it in the final document that we're going to consider, because we're going to consider them as a package.
Okay.
Okay?
That's what the vote's-
But we have
that's
to
what the
make
vote's
some
for.
policy decisions, or they can't correct us.
All right, that's
Okay.
what the vote is for, is what's going to go in the final document for consideration.
Okay, next item, signage. Pete you and I had put in language, let me see if I can find it.
I think Susan solved that problem because
No, it's-
she put up other sign posts so that
Well,
you can
but
have
there's-
up to 3 signs there now. Before, we only had one area to put a sign up, and when there was an event there that was continuing, we took it down so that the person's event that day would be up there. But she's got, we have,
What about on the island? I thought that was limited to 2.
to what?
I think the planning board was looking at that too.
No, but we're talking about the park.
I understand that, but the signs are not just at the park, they're in other places too.
In front of the restrooms, in front of the pier.
I want language in there, I can't find it now, this is the problem of trying to deal with 4,000
Susan.
pieces of paper.
Susan Parker.
Susan's got it. Susan's got it.
With regard to signs that are not related to the use of the park or the special event policy, you must allow the special event sign language that is in the UDO. And it does address that and plans to address that, and it'll come before you within a month. You don't need a separate reference to the signs. You can't conflict with your UDO language.
No, but before you came up with that thing, here, I just found the thing, I would have put in something that says, space for signs is very limited. The town reserves the right to allow different organizations to display their signs for closely scheduled events. In other words, we can't put ourselves, and this happened recently, where one event was coming in and there were the 2 sign things were being used, and the person who had one of her signs in that area wouldn't allow this major event to put up their sign.
Right, but
I don't care if we have 3 in there, I don't care what goes on. The point is, the town should be able to control that
that-
and make changes if we think nobody is buying the right to keep up a sign for whatever. That's not appropriate.
But what Susan said is that's controlled by the UDO. So if you just make a reference, no?
Now, you have general sign requirements. We can have extra requirements for the park. And what I would like to see is language in there that gives us the ability to not have somebody, you know, to not give somebody an unalienable right to put up a sign in one of those areas.
We never did. That statement you made is not an inaccurate statement. There was a misunderstanding between the 2. Even I took one banner down accidentally, and it was a new banner because I didn't look at it. I do control the signs and, and make sure, and in putting the additional posts, that is not an issue. It is a
Okay,
non-issue.
fine, but that language will be helpful in the permit application, which gives them the right to put up a sign.
We have language in the application.
don't. It's
I
not
do
in there.
too. That's not accurate.
There is not language in the application or in our regs on signs that specifically states we reserve the right to make changes. That just because you get a permit, which allows you to put up a sign, that doesn't mean that you are absolutely guaranteed that your sign is going to be up there every week. We have to be able to control this.
Well, we do, and Grady has recommended additional language that will be placed on the application that does reserve our right. We've always had that right, but we'll make it clear in the
I want to
application.
make sure it's clear. I just gave you some proposed possible language. I think that's an important issue.
All right, the next.
Okay, limits on number of
Wait,
events.
wait,
There's
there's-
another major policy thing here on how many.
Wait a minute, we're doing one document at a time. What are you
It's
in?
in too many places. That language I gave you was on page number 12 of the rules and regulations for the UDO chapter, at the end of chapter 99.
It's the code
It's
of
in the
ordinances,
ordinance.
not the UDO.
When it talks about signs, banners, whatever is, and then somewhere else, there's something in there unless it's in.
Don't
unless
confuse the
it's in
policy with the
event permit,
ordinance.
You know, the event,
The signs are covered in 99.28 under the rules and regulations, if that's what we're covering now.
anyway, the point is, let's make sure that the town reserves has the right to make changes
Absolutely.
to that.
Will
And that
do.
somebody doesn't think that just because they have a permit, they can do that every week.
I don't
And-
think-
and they
I-
don't.
I don't think anybody has a problem with that.
Okay.
All right,
And by the way, I just want to give a shout out to Linda Ruddick. I thought your comments were very well stated. in your
Yeah,
comment.
she
You
caught,
sent in
she
the
caught the
section.
conflicts that in my rush to get this out the door, I
Yeah,
missed.
that was-
But the attorney caught it too. And I caught it on Monday, so we're good.
That was good. Okay, limits on the number of events. I've been thinking about this, and I'm not quite sure how to do it. I would like to see something like no more than two, absolutely no more than 2 high-impact events and 1 medium-impact event a week. I think that's a lot.
A week?
Low impact, no problem. If you think it should be less than that, speak up. I mean, but that's an issue that we need to discuss.
Well, I talked to Susan earlier about weddings and other high-impact areas. I think.
Weddings is a different
Well, I
issue.
know.
Okay.
But, you know, I think one major event a month is fine. You know, we don't, the park is for everybody. And I know that even if the event's going on, people can go there. But I don't want to tie it up.
You can't do it once a month. You've got the gift market in there every week.
Well, weddings, I know we're talking about, but still, 1 or 2 events a month total. If you want one a week, I think that's too much.
I want to put a limit on it, and if that proves to be too much, you can change it down the road. But at least let's start with a limit. Right now, we have no
Susan,
limit.
is there a limit in there, in any of these documents?
Yes, I recommended no more than 3 high-impact events a
And I think
week.
3 a week, high-impact events is too much. So I would have said 2 high-impact and 1 medium.
That's a week. As we discussed, like Veterans Day. You have the Veterans Day event on Monday. You have the starting of the farmer's market on Thursday. And generally, that's when the yoga and the
That's a
women's...
low-impact event.
Hold on. And that's when the yoga and the women's circle people. We already have 3 events going on. Having to allow 3 a week doesn't mean you're going to have 3, especially if you put the limit on the number of weddings. If you're going to allow 1 wedding a month, you're going to have to allow for 3 high impacts a week, given the holidays and different events.
No, I don't want to do that to allow weddings. 3 high-impact events a week is too much. It's just too much.
Well, I do respectfully disagree, having managed it, but I will, of course,
That's why
follow
I'm raising
the
this as
council's
a-
advice.
That's why I'm raising this as a policy, for a policy discussion.
I do believe we should limit the high impact. Do we ever have more than 3 a week? We do?
Not more than 3, up to.
Carol, what do you suggest?
Have you ever had that
I would
many?
suggest
no
no
more
more
than
than
2?
2 high impact and 1 medium impact a week.
A
and
week.
Let's see how that works.
That's fine. I don't have any trouble with that.
Just to let you know, the majority of your events, i.e., they're not here anymore, Pausability, Strawberry and Wine Festival, those are all high-impact events. They have more than 150 people. I just want you to be aware of that.
They're all one week. But there's also weeks go by we don't have any high.
This summer, except for the market, but this summer we had no events. We had the last one, the first Sunday in June, and we haven't had one since.
That's okay.
Yeah, well, and it's mean. I mean, that's not what you're going to get. I mean, I don't know why are we making rules for what we're not experiencing. If we want to put something in there that, I mean, I had a comfort level with our one wedding that, initially I was nervous because of the amount of people they thought were going to show up. And then when I went out there to double check, it was much less. It was about 110, and it worked just fine. They cleaned the bathrooms, they did the toilet paper, they did the micro trash. They had people drive together, carpool together to limit the amount of vehicles in the park. I mean, they did a really good job. And if you had gone there the Saturday afterwards, you would have never known there was an event.
By the way, we had put in language, you took it out, and I want to put it back in. The number 8, old number 8, under the chapter 99, the last couple of pages, there was language in there for sign, saying even if requested and approved, the town reserves the right to allow a different organization to, you say also display, I would say to display its sign.
Right, that does not belong in an ordinance, that belongs in the policy.
Okay, as long as
That's the
language-
comment that
as
I
said,
made.
As long as language goes.
Yeah, I took it out and said it needs to be placed in the special event policy.
All right,
Because, as you know, the ordinance are the rules that are enforced by the police department.
All right, you
Policy, sorry, one more. Policy is my administrative guide in order to apply the rules.
Well, does that apply? You also took out number 9. Any organization that uses the park for an approved event permit must allow regular visitors to access the park and make clear that entrance fees are voluntary.
And I said, we will add that. There's
Into the, not
policy.
here, but into the policy.
Yes,
That's
there's
fine.
language
I
to
didn't
that
know why you
effect.
took it out.
All right,
Okay.
so with regard to this issue, you're going to get on the October 17th, there's going to be alternatives of 2 and 3. That's what seems to be the difficult. Well, we're not going to, we said we're not going to vote on it, so I'm
We're
just,
not
the
voting on
alternatives.
acceptance of the whole policy, but if we don't vote now, how is she going to do this? I don't want to see 4 alternatives show up on, this is just,
Bobby, we
then
have
it's
to
going to
narrow
get
it down.
continued again.
I
So we're not ready to take a vote because we have all of these questions that we're trying to get into something that we can then read in one coherent package. So I'm saying the next issue is there are places, and I can't find it now, where we talk about liability insurance. And are we requiring liability? One place it says you may put it in, other places it says they will have this.
They shall, and that was the one word I missed in all of my searches. It
Okay,
says
so-
may, shall is in there.
Okay, so I have 2 questions on this.
Yes.
I can understand why on a little event or whatever, it's a burden to have people all of a sudden have to go out and get liability insurance, and I appreciate that. But what are your criteria for deciding whether or not somebody has to have it or not? And if it's a high-impact event, they better have it. If it's a medium-impact event, they better have it. If it's a wedding, they better have it.
Well, no, how do I put this? To require insurance for the use of the park, because it's a public event, it is an event outside the normal use of the park. We are covered via liability on people using the park on a daily basis. However, when you bring in an event, and I'll use plausibility, you bring in an event with a number of dogs, and there's a risk.
Okay, so I'm asking you, you had language in there that wasn't clear.
It says shall, and they do, list us as additionally insured. Weddings are a different matter. Weddings are not public. They're not bringing people in. They're not inviting the public to it. They are renting it. So we do have a liability release and express assumption of risk that both myself and this is what most communities use for weddings.
Again, just make sure that
We're covered.
covered and we're getting it when we need it.
Yes, ma'am.
Okay, we did have something in there, I know what the answer of this is going to be. I thought that it made sense to have council approve permits for high-impact events with these other rules and regulations. That's less necessary, but I do want to point something out, Susan. You had put something in there, you took it out, and your notation was that we are the appeal body.
Yes.
You know, Susan, we're a mayor-council form of government, which means we are the administrators. We are not just the appeal body, and we do have responsibilities for administering. We are not a council manager form of government where that would apply. So it's those statements that I've been more and more troubled with, that council is being kept out of the loop on a lot of administrative things that I think we should be kept in the loop on. And let's just be careful when we make those statements, because we don't necessarily agree with you that we couldn't do that.
It's the same rationale as building permits. You do not issue building permits either. You can't.
I'm just saying as a general statement, I just want to make sure that that's clear, and I don't mind us not making that decision.
I do agree with Carol that we should be somewhat involved in major issues in the park.
Can't hear you, Mark.
I'm sorry. I think we should be involved in major issues in the park.
And what issues are you referring
Yeah,
to?
just high impact areas, Susan. I mean, other than that, you take care of it. But if there's something different that comes in there, like a rally or a protest, or I think that the town council should
I
look
will
at that.
absolutely update you on I would say, extraordinary events. I've done it before, I will do it again.
That's fine with me.
Yeah, I mean, I've already been doing it.
I want to
Okay, and
I want to
what-
make a change that we don't allow any Civil War statues.
I'm sorry, one's being delivered tomorrow.
Okay, the last item, and there are some more things, and I can come in, you know, and also, if you get this thing out, we'll all send back additional changes. Weddings, policy on weddings, I am
But no,
still,
before we do, does anybody else have discussions on the policy or Chapter 99 on things that they need included? Okay.
we got to get a
Okay.
clean version before.
Well,
we
no,
can-
I understand that, I understand that. All right, we've gone through basically the policy, Chapter 99,
I'd like-
Susan's mentioned the liability release, and now we're on the wedding policy, which is something brand new.
So I still have a problem with having weddings in the park. You're talking about people closing the park off, having a private event. My concern is you're talking about a large tent getting erected, and there are not going to be no tie downs, the way the gift market very kindly says to their tent people that they can't drive stakes into the ground, that they have to be self-tied. And I'm sure that with a large tent, it's going to be staked in the ground. There's music late, which affects the surrounding neighbors. My biggest concern is the thing in weddings these days with young kids is that the amount of drinking is really quite frightening, and these kids get totally drunk. I mean, where they can't even walk.
What is different from 50 years ago?
Uh,
I mean, my wedding was
Maybe the
kind of like
availability
that.
of liquor, that's a good question, I don't know, but I don't remember people getting as drunk in my days as I see them getting drunk
Well,
now.
I
I
want-
have a problem with weddings.
Yeah.
If we limited it, you know, you could limit it, you suggested this, Susan, I thought this was a good suggestion, you said, you know, one a month. And then in 6 months, if that's too much or whatever, the new council can change that and make, you know, but that's a good suggestion, that we at least limit it. You know, we're talking about basically giving somebody a free venue. And, you know, if you go out, my son had a wedding in a place in New Hampshire on grounds. He had to rent a tent and caterers and the whole bit, but it was the grounds that were lovely, and restrooms in a building that was on the thing. I don't know what he rented it for, but I'm sure it was more than $200. I don't want to see people from all the surrounding areas say, oh, Sunset Beach, free venue, let's have a wedding there, because it really doesn't cost anything.
Well, you know, like.
I don't think it's in our best interest to be doing
I
that.
just-
Well, like
I wanna
Pete says, we could readdress this in 6 months if we think it's a problem.
Yeah, and that's why I suggested be in the policy and not in an ordinance. I do want to correct one thing you said, though, that I don't think you meant to say it, is that they don't close the park for a wedding. You said they closed the park for a wedding.
Well, there's certain areas they are reserving and restricting. You've got in here about restricting use of certain areas of the park. People are coming in to reserve certain, that's how it reads.
It's not restricted.
So I can crash the wedding?
Yeah.
All right, let's go.
Same as on the beach.
Free liquor, let's go.
That is part, when I speak to them, I said, you need to be aware.
If they pay for the covered picnic area, then it is theirs.
Yeah, the pavilion, or the covered picnic area, yes. You reserve that exclusively, but the rest of the park is not. And that is stated to them right up front, that it's not an exclusive use of the park, and that you cannot restrict any people from the park.
Do you have something in there, I don't remember, saying one a month or something?
No, that was, we just talked about it now, but we will add that.
Have you had that, what kind of demand have you had, level of interest in terms of having weddings in the park that would like require a tent or something?
It just started. Without the bathrooms in the covered area, I don't think anyone thought it was a viable option at all. And what we've done is, people have called, and I mentioned to them non-exclusive, you know, and the additional charges, and they're like mulling it, they're, oh, well, you know,
And you limit the number of people.
yes,
Is there a limit?
100.
You just say 100 chairs.
Yeah, well, I'm gonna
You're
revise
gonna make it
that.
Perfect.
Okay,
Okay? I think we're all good with that.
yeah.
That's what
I
I've
like the
got.
idea of having weddings in the park.
I do
I
have
mean,
certain
and making
board
that
changes,
available
but I
to
can come
people.
and make
Okay,
them now.
that's good.
Oh, my gosh. You know, we never do this, Linda.
I set up, I talked to Susan, I took the dog over the day of the wedding. It was lovely, you should have seen it.
It really was.
It was.
Okay,
That one.
that's my list. Anybody have anything else?
I think we covered it all.
All right. Then we're going to have Susan's going to prepare or have prepared a document that we can take action on for the next meeting.
Get the sidewalk, Bonnie.
Why do we care if it's free alcohol at a wedding or if it's a cash bar?
That is a state requirement.
It's a
If they're gonna
licensing
use a
requirement.
special occasion permit,
It's a licensing difference.
That's interesting.
it's a state, yes.
So you cannot have a cash bar.
Not under the special occasion permit.
You can.
The wedding planner may have an off-site premise permit, which is different. But for a special occasion event permit by the state, it has to be free.
No, it doesn't.
Yeah, it does.
I've just got 2 permits for nonprofits to,
But it's not a wedding. We're talking expressly weddings. You have a different type of permit for yours. There's 5 different permits, sir.
take back.
There's 5
Either that-
different permits.
You should hope, otherwise we're going to send you to jail.
And I'm going to rephrase that too a little bit, because there are different type of permits, like for nonprofits, if they bring down a beer vendor from Wilmington, sorry, Bonnie, bring down a vendor from Wilmington that sells beer, if he has an off-site premise permit, it goes right through his on-site and off-site premise permit.
All right. Bonnie, you're just moving monies around. We haven't approved doing this yet. We haven't gotten bids. You know, I'm probably the lone voice on here who thinks
Correct.
that we don't need to spend $500,000 on a sidewalk.
Oh.
But this is not that discussion.
No, it's just where the money is coming from. Last meeting, you approved a budget amendment, which was based on the action you took at the meeting prior to that one. And I'm recommending that we restore the general fund and take money from 2 other capital reserve funds that are currently sitting there.
It's been explained to me is,
Yeah.
what historically has happened is separate funds were set up for different things, and they've
Right.
accumulated money in them, and we're trying to close those out.
Right.
Because they don't serve any particular purpose except confusion.
Do you want a motion?
Please.
I move we make the changes as you requested.
All those in favor?
Aye.
Aye.
Opposed?
Thank you.
Good night.
Get you out of here. All right, Dustin.
Dun, 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 dun.
I make a motion.
In front of you is the 2017-2018 street resurfacing project. This includes Holly Lane from Park Road to Indigo Circle, Waterway Drive, Stokes Court, and the parking lot here at Sunset Beach Town Hall. We had 2 bidders, the Barnhill Construction Company. They come in at $172,610. And Highland Paving Company, they come in $149,500.
Has Highland ever done anything for us?
Yes. they
Highland
have.
did the Main Street asphalt
And
for
our-
the bike paths.
Who did the 40th Street? That wasn't Barnhill.
No, that was Barnhill. That was years ago.
That was who?
That was Barnhill years ago. Highland just done the street resurfacing for us this past year.
And we're happy?
Yes.
That's $149,000.
I just wanted to make sure it wasn't.
Yes.
Okay.
That's for
for
Town
all
Hall.
those locations?
Yeah, for all 3 roads and Town Hall.
Do I have a motion to,
What did we budget?
So move.
We budgeted 200.
200?
200.
200. Yes.
Perfect.
Justin, is this coming out of the Powell bill?
The streets will come out of Powell Bill, the parking lot here will come out of Buildings and Grounds.
This motion, any other discussion? All those in favor?
Aye.
Aye. Opposed? The next is acceptance of resignation of Robert Tone and authorization for the clerk to advertise the position.
So moved.
Discussion? All those in favor?
Aye.
Opposed?
It's a housekeeping.
Consideration of approval of the... Yeah, there's a police department, every time you change a chief, you gotta
Right.
execute new, and we did them with the other towns, we haven't
I
done them with
move
the...
we approve the mutual aid agreement as stated in the attachment.
Any discussion?
I have a couple of questions. I have no objection to doing that, but I just curiosity about this. Have we ever had one with, we have one with New Hanover now?
I don't believe so. I didn't see one in the file. I don't believe we've had this before.
Okay.
The reason that I'm asking for it is, as I was implementing new policies, reviewing existing policies, I asked the Brunswick County Sheriff's Office if they had the ability to deal with an explosive device. Should there be one found, should there be a threat of one? They do not. New Hanover County does have an explosives unit. In talking with their sheriff, the need for the mutual aid agreement came up in case we do need that resource. That's the only reason that, that this is here before us.
Does either Brunswick or New Hanover, do they have a SWAT team?
Both do.
Both do? Oh,
Yes, and we
obviously.
do have a mutual aid agreement currently in place with Brunswick County. Should the need arise for any resources from New Hanover County once this is in place, so we're not specifically just narrowly tailoring this to the explosives unit. It's mutual aid as a whole. So if something were to happen and we would need that resource, it's there.
Have we used these in the past recently?
The mutual aid agreements?
Yes.
Yes, we have,
And
absolutely.
can you give sort of a example of how they were, what kind of event, what kind of incident?
Sure. I know we use them for special events like the marathon. We use them for traffic control. Oftentimes there's only two of us working, and if our two guys are tied up with a domestic and another domestic comes in on another side of town, mutual aid agreements come into place where Ocean Isle might have to come and respond. Brunswick County Sheriff's Office may have to respond.
You needed it for the Hardee's incident, didn't you?
Absolutely, yeah. We used their canine. They had resources that, that came from both Ocean Isle and Brunswick County for that incident.
Did you catch him?
Not yet.
Okay. Thank you.
You're welcome.
All right, all those in favor?
Aye.
Opposed?
Thank you.
Thanks, Chief. Review the upcoming agenda items.
Can we, we're going to put the park rules on, right, for October
Yes.
17th?
Yes.
Palm Cove appeal hearing for 11/21. I have a question mark for the East End access issue. I don't know when we're going to get our information, but I assume you want that sooner than, I left a question mark. I'll leave that to you and
Yeah, I'll
staff.
start on it tomorrow.
Beach wrap-up, we don't have that on the schedule, and we need that, and I would put that on for October 17th.
When you say beach wrap, you talking about?
How-
Beach patrol.
What
and
happened,
summer
how
wet.
it worked, what they would like to see changed, issues, yeah.
Okay.
That's plenty.
I agree.
Okay, anything else? All right, next item is public comments. Once again, I limit it, if you step forward and state your name and address, and try and limit your comments to 3 minutes. Karen, Mr. Joseph?
Karen Joseph, 915 Sandpiper Bay Drive. I just wanted to share with you, when you are discussing these park rules, that those of you who are familiar with the very large tent that we have at Sunset, which is some 30 feet long, they anchor that by using water barrels because you can't anchor into the asphalt. Tents a little smaller are anchored by PVC pipe filled either with cement or sand. Again, all those tent companies are getting away from staking their tents. So I just wanted to share that with you and encourage you to give some serious consideration to the alternative, well, it's not an alternative, it's an addition that John put forward on events that occur for more than one day. To chase away any event that wants to come to our town, I think is bad public policy and does not enhance the image of Sunset Beach as being the friendly community it claims to be. I've seen major events in the park. I'm involved in at least 2 of them every year, and the impact is minimal, and I've never seen any damage. So I encourage you to be as broad-minded as you can be when you finally come to a conclusion on this.
Thank you.
Thank you.
My name is Jim Skiff. I live at 414 33rd Street. I'd just like to express a concern about the ongoing or the continuation of our involvement with Jaguar's Lair. I think way back when the town got involved in it, and I won't pretend to know all of the background, I think our heart was in the right place. I think individuals on council tried to work with the developer to negotiate some type of settlement that would be good for the individuals who own the lots there. But I just think there's a time where we ought to cut and run on this. I was given a number of legal fees of approximately $10,000. My understanding is that that number is far greater. And I just think we're putting bad money or good money after bad for a development that is not going to give us any taxes or add anything to this community. The last piece of information that I read on this is that now we're going to, the developer is agreeing to go forward with what he originally agreed to do. And I think in the long run, we're going to end up exactly where we are right now, and we'll have just spent a lot more money on legal fees as well as individuals' times. So I just ask you that you take that under advisement. Thank you very much.
Thank you.
Yeah, just,
to come see you after.
yeah, if you could hang around for a couple minutes, I would like to speak with you. Sure. Okay.
Linda Rudick, 1008 Park Road. 2 things. One is, maybe there was a wedding section that I didn't see. I apologize.
It's part of the package.
So some of my comments may have not considered that. So I apologize for that. And secondly, I don't know about ordinances, laws, whatever, but it seems like in Sunset Beach, since we haven't had the Brunswick Beacon sponsoring a forum for our candidates, we've not had them in a couple of years. If there's some law against the town sponsoring it, I'm not aware of it. But I think we all want to have good government, and I think we should be sponsoring those in the future. I think it's incumbent upon us to make as many people as possible aware of who's running, what they think, what they're going to do for our town. And so I make a plea, if it's not against the laws, we consider that for future elections.
Thank you.
We could do it in the park, too.
We'd have to put up the $175. Anyway, I know, well, other members of the
I can
public?
get a good PA system, though.
Other members of the public? All right, none appearing. I'll entertain a motion to adjourn.
So moved.
All those in favor?
Aye.
We're adjourned.
Tough day tomorrow.